When it comes to the subject of this video, it is very difficult to find not only authoritative, but truthful sources. And the example we're using even has a suspicious motive for its writing. However, the feelings of unjust treatment come through, especially as it pertains to the American robed noblesse, what most often referred to as judges, which are far from anything honorable, of course. However, in this book, it explains the situation of the past. It was published in 1900, so some truth still gets through, even though much of what is contained in the book is a lie and must be considered, or the motives of the writers must be considered. However, it describes a situation in which the robed noblesse of America does not hold the position of prominence that we are taught today. In fact, far from it. The robed noblesse was so hated and despised by the people that they felt that a fitting justice for those types of individuals was to keep them as a sort of domesticated house pet of the legislature. This book that I am pulling this example from, which can be corroborated in other works that I have used, such as The Levantine Adventurer and other things that take from first-hand accounts, true first-hand accounts, not edited first-hand accounts that are frauds, because we have a lot of those, but things that, logically speaking, make sense and where you can find no bias on the side of the writer. But this book is called A History of Adams County, Ohio, from its earliest settlement to the present time, including character sketches of prominent persons identified with the first century of the county's growth, and blah blah blah. It was published by Nelson W. Evans and Emmons B. Stivers. Now there's a Stivers who recently won election, I believe, or lost election, I don't remember, I don't really care, but most of those people are frauds anyway. But it was published by West Union, Ohio, published by E.B. Stivers in 1900. And in the chapter, Courts Under the Constitution, there's a very interesting list of charges that are brought before a first example. And this is in reference to Robert F. Slaughter, who was the third presiding judge of Adams County. He was born in Culpeper County, Virginia in 1770. Of his childhood, nothing is known, but at the age of 17, he came to Kentucky and volunteered as an Indian fighter. He went to Chillicothe as early as 1796 at the founding of the city and studied law. He was admitted to the bar in Chillicothe, Ohio in 1799 and began practicing there. Now, I don't know what the writers mean by being admitted to the bar, because that would have meant something entirely different then. Now we think it means you go and take a standardized test, but then it would just meant he was admitted into a courtroom. He seemed to have traded and trafficked about considerable in lands, as everyone did at that time, but was a poor manager. In 1800, he purchased a farm about 1.5 miles south of Lancaster and made his home there until his death. He was a merchant first, but gave up that business and opened a law office in Chillicothe. In 1802, he was a candidate from his county for the state constitutional convention, but was third in the race. He was careless about his obligations, and in 1803 and 1804, he was sued for debts many times. He was elected and presiding judge in 1805 and was elected to the state senate 1803 to 1805 from Fairfield County. February 7th, in place of Wylis Silliman, resigned. His circuit was very large and his salary very small. And there you get the idea and the way that people saw these individuals, what we are taught now to see as honorable and to see as illustrious titles, they then saw as a joke, because they despised these people, as can be founded by as evidence of can be found by their treatment of others that you can find in the Levantine Adventure and other books that talk about the situation of the 17th century and how the long history of abuses, just as we have now, comes directly from this robed noblesse that think themselves our superiors in all regards. In continuation, he had the Second Circuit and had to ride horseback to his appointments. The salary was only $750, and the creeks were without bridges. There were no ferries, and the swimming was risky. The judge would miss his courts, and the legislature determined to make an object lesson of him. Legislatures are fond of displaying their power, and the one of 1807 was no exception to the rule. January 8, 1807, charges were filed against him in impeachment. Of course, I don't really know what legislatures they're talking about, because we certainly don't have any powerful legislatures today, because our legislatures are all puppets and employees of foreigners, essentially, and this strange nobility system that we seem to still live under, despite it being overthrown so many centuries ago, apparently. Anyway, the charges were he failed to attend the March term 1805 in Adams County, failing to attend same term in Scioto County, failing to attend spring term in 1805 in Gallia County, failing to attend July term same year in Franklin County, failing to attend fall term 1805 in Scioto County, failing to attend fall term 1805 in Athens County, failing to attend spring term 1806 in Highland County, failing to punctually attend spring term 1806 in Adams County, failing to attend spring term 1806 in Scioto County, failing to attend spring term 1806 in Gallia County, failing to attend summer term 1806 in Adams County, failing to attend summer term 1806 in Athens County, failing to attend summer term 1806 in Gallia County, and failing to punctually attend the fall term of Fairfield County in 1806, failing to attend fall term of 1806 in Franklin County. Now, of course, he argues why he failed to attend these terms, and likely most are lies because he was impeached. And that decision can be found on page 175, where it states, on the question of his being guilty of neglect of official duty, the yea vote was Claypool, Core, Hampstead, the Speaker, Thomas Kirker, Mr. Schofield alone voted he was not guilty. On January 29th, the respondent was called but made no answer. Though 3 times solemnly called, the Speaker delivered the judgment of the court that he had been found guilty of neglect of duty and should be removed from office. His removal did not seem to affect his health or spirits or his standing among the people of Fairfield County, and that blah, blah, blah. We get all of the writers' attempt to explain this away as, oh, it was just the nasty legislature. No, it's because these robed noblesse people are nasty individuals, and they were as equally despised then as they are now by all. At least at the time they were despised by all, but now we seem to have a lot of people with their stupid Back the Blue movement that seem to be in love with these robed noblesse individuals. But this is not an isolated case, and perhaps the second example is more entertaining. And this is in the case of John Thompson, who was the presiding common pleas judge of Adams County. Now notice that term common pleas meant something as a joke at the time, and now it means something serious and grave. But from April 9, 1810 to March 29, 1824, he was a resident of Chillicothe, Ross County, Ohio. He located there in 1806 from Chambersburg, Pennsylvania. He was elected presiding judge in 1810, re-elected in 1817, and served until 1824. His circuit was composed of Franklin, that's spelled Fracklin, but Madison, Fayette, Highland, Adams, Scioto, Gallia, and Ross. He was a member of the Presbyterian Church and an elder in it. What a surprise. He was also a total abstainer from alcoholic drinks. That's probably a lie. He was an acute lawyer, but narrow-minded, firm to stubbornness, of considerable reading, and of much readiness. Blah, blah, blah. In 1812, he was impeached by the House and tried by the Senate. The following were the charges exhibited against him. First, because he allowed the attorneys but 10 minutes to decide in a larceny case in Highland County, and when they objected, said that if they did not take it, he would allow them but 5 minutes to decide. Second, because he refused to allow an attorney to testify for his client in a case of usurpation in office, the attorney having offered to testify. Now, mind you, the writers of this book are attempting to change history in this work. And so it is unlikely that the word attorney was used, but we don't really know because of all of the manipulation of documents and historical records that has been going on. In continuation, second, because he refused to allow an attorney to testify for a case in usurpation in office, the attorney having offered to testify. Third, because he ordered certain court constables to knock down certain bystanders with their staves and gave no reason therefor. Fourth, because he allowed a bill of exceptions contrary to the facts. Fifth, because he declared an assault and battery case that the attorneys had no right to argue the facts to a jury except with the permission of the court, and then when overruled by his associates, impatiently told the jury to go on. Sixth, because in a larceny case, when the judge came back into court and wanted to re-examine the witnesses, he refused them and sent them back, telling them the case was too trifling to take up in the time of the court. Seventh, because he ordered a jury to be sworn in a robbery case after they had all stood up and said that they had made up their minds and they found the defendant guilty without leaving the box. 8, because he said publicly the people were their own worst enemies, that they were cursed brutes and worse than brutes. Yes, now imagine that. That's a so-called officer of the court, and that's what he's quoted as saying. That's no surprise. I would highly expect the detestable, dishonorable individuals that occupy those offices today to use the same wording. And let's read that again. 8. Because he said publicly, the people were their own worst enemies. They were cursed brutes and worse than brutes. And there you get contempt for the people. That is the sign, always, that you are dealing with an enemy and a corrupt individual. In continuation, 9th, because at Hillsborough he had refused to sign a bill of exceptions and had refused to let an appeal to be docked. 10th, because at a trial at Gallipolis he had unjustly and arbitrarily allowed an attorney but 25 minutes for an argument to the jury, and then when the limit of time was reached and ordered him to sit down, saying the jury would do justice in the case. 11th, because at Gallipolis he ordered the prosecuting attorney not to let any testimony go before the grand jury until he knew what it was. 12th, because he said to the grand jury at Circleville that our government was the most corrupt and perfidious in the world, and the people were their own enemies, that they were devils in men's clothing. And that is a perfect example of the sentiment shared by all robe noblesse licensed barristers, masters, and associates in their little Inns of Court. That is who they are. And you have to ask yourself, or at least I have to ask myself, I suppose, why does the legislature not conduct these examinations anymore? Because most of the people that we have presiding are guilty of these particular things that were brought before these two individuals, among others, of course. Anyway, that is a helpful example of how the true situation was viewed towards these Supreme Court morons at the time. But unfortunately, there are very few books and that are truthful about the matter. And mind you, this book is coming from the perspective of being in support of the honorability of the robed noblesse. And even they are mentioning these circumstances and the charges brought before these despicable individuals. And justly so, they were paid very little, kept on a very tight leash, and led about kind of like a entry-level job as they would treat them. Now, interestingly, I went to the Library of Congress's website. And in the section Dun & Bradstreet Reference Book Collection, it states, R.G. Dun & Company, now known as Dun & Bradstreet, was a credit reporting agency that provided ratings on an enterprise's financial strength and ability to pay back debts. Now, I thought Dun & Bradstreet was still around, but apparently it was, as in past tense. And of course, when you click on it for documents, it states we were experiencing technical difficulties. How convenient. Now, in my own life, I've ran into some rather disturbing elements. In the history of the Roush family in America, from its founding by John Adam Roush in 1736 to the present time by Reverend Lester Leroy Roush, AB, 6th generation from its founder, and this was published in 1928 by Shenandoah Publishing House, Inc., Strasburg, Virginia. There's a couple things to notice in here. First, it gives us a few examples of evidence of tampering, made-up statements, and false records. In the preface, which is where most of our stuff will be taken from for this, under the 13th page, it states, the reader who has knowledge of family history will not be surprised at some of these incompleted portions. He will rather be surprisingly gratified to see in what a comprehensive way we have been able to develop with accuracy and substantiate the authentic record their history from the time of their landing in American soil till the present generation. Few families have been able to prove the military service of their ancestry with the accuracy that we are enabled to give for these brothers. Officers of high rank during the Revolutionary War in some cases have no official record of their service. Isn't that interesting? That sounds like a made-up backstory to me. The descent of some of these cannot prove their eligibility to the sons or the daughters of the American Revolution, even though the same soldier later held so responsible a position as governor of a state. That sounds similar like all of the crap that was being said about that traitor Mattis, that he would go around and visit bases, although I never saw any of that. But go figure. Most people who hold prominent positions got there through fraud because all of their friends are there through fraud and so on and so forth. But that might not always be the case. Anyway, on page 12, it states that President William McKinley corrected an error of nearly a year in his birth when or while he was President of the United States. That sounds like covering tracks for fraudulent documents. I've seen that done quite a few times. And then, in a different section, there's a really interesting thing that's stated, and that is that it has been our ambition to hold the cost of the volume at the lowest possible amount so that it might be in practicality every family of the name and blood of Roush, that it may be of inspiration to coming generations, challenging them to a nobler citizenship and higher ideals. I wonder what that nobler citizenship is, and I wonder why just being a U.S. citizen isn't noble in itself. Anyway, is the great hope of the author. If this is done, he will feel amply compensated for a work for which money cannot pay. Sounds like somebody made a promise in blood and promised away the blood of the family, as most blood promises go. Anyway, if you have enjoyed this video, please like it, share it, subscribe to my channel, and check out any other content that I may have published, especially my writing. I do publish books. And as always, stay tuned, there will be more.